Hello, everyone, and welcome to our second professional development luncheon, Advice from the Bench. Before we get started, I'd like to introduce, she's taking a sip for pop there, Ms. Paula Holderman, our president of the ISBA, came to join us today, so we want to thank her for coming. Thank you. And then the chair of our young lawyers, Jean Keenel is here. And then I'd also like to thank my two co-chairs on the Professional Development Committee. We have George Schoenbeck and Heather Pfeffer over there. And if you have any questions during this presentation, they both have microphones. And you need to have the microphone in your hand in order to ask your questions so we can record it because we're being taped right now for our YouTube channel. So just raise your hand and wait for either Heather or George to come to you, and I will call on you and get your question in. We want this to be interactive, so please ask questions. Now I'd like to introduce our panel for today. We have three esteemed judges, and I have a little biographical information about them for you. At the far end there, we have Judge James F. Holderman. He has been a U.S. District Judge since 1985 and has served as the Chief Judge of the Northern District of Illinois from July 1st, 2006 to June 30th of this year. Before his appointment to the U.S. District Court, Judge Holderman was a partner in the law firm now known as Denton's, where he specialized in federal court litigation. Judge Holderman has also served for 6 years as an Assistant United States Attorney in Chicago. He's presided over numerous cases in all areas of federal jurisdiction, and he's also served by designation on the United States Courts of Appeals for the Seventh Circuit and the Federal Circuit. He's chaired the ABA's Commission on the American Jury, served as a co-chair on the Seventh Circuit Bar Association American Jury Commission, is a founding member of the ongoing Seventh Circuit Electronic Discovery Pilot Program, and sits on the seven-member board of the Federal Judicial Center, chaired by Chief Justice John Roberts. He received his undergrad and law degree at U of I. And then to his right, we have Judge Thomas Mulroy. Judge Mulroy has been on the bench since 2007. He sits in the Law Division Commercial Section over here in Cook County at the Daly Center. Prior to becoming a judge, he was an Assistant United States Attorney in Chicago, and then he was a partner at Jenner and Block. He was a commercial trial lawyer with a national practice representing clients in complex litigation in state and federal courts. He has written and taught on trial practice issues, including evidence, expert witnesses, and discovery. He is a fellow in the American College of Trial Lawyers and a member of the Board of Governors of Loyola University School of Law and a member of the Board of Managers of the Chicago Bar Association. In addition, Judge Mulroy was a special counsel for the Attorney Registration and Disciplinary Commission, a chairman of the ABA Civil Practice and Evidence Committee, a director of the Illinois Institute for Continuing Legal Education, a director and life member of the Illinois Bar Foundation, and a member of the Chicago Bar Association, an adjunct professor of law at Loyola University, Northwestern University, and DePaul University. And then finally, but last but not least, we have Judge Laura Liu. Judge Laura Liu was appointed by the Illinois Supreme Court. maybe I'm foreseeing something here in the future. On December 14th, 2010, and she was subsequently elected to the position from the 8th Judicial Subcircuit in the 2012 general election. She is currently assigned to the Chancery Division, where she presides over a docket of approximately 6,500 commercial and residential foreclosure cases. Judge Liu serves as a co-chair of the Language Access Committee of the Illinois Supreme Court Commission on Access to Justice. She was appointed to serve as a member of the Committee on Education for the Judicial Conference of Illinois. She is the immediate past president of the Illinois Judges Foundation and current chair of the Foundation's Access to Justice Grants Committee. In 2012, she was the recipient of the Cook County State's Attorney Asian Pacific American Community Service Award and the Sandra Otaka Distinguished Judicial Service Award. She's a faculty member of the 2014 Education Conference for State of Illinois Judges, and prior to her appointment to the bench, Judge Liu was engaged in private practice for 19 years, handling litigation matters involving commercial disputes, healthcare fraud, and labor relations in state and federal courts. Okay, so we have a distinguished panel for us here today, and we wanted to start out. Judge Holderman was kind enough to make a PowerPoint for us that essentially answers the question, what do you need to do before you ever appear before a judge in their courtroom? So I'm gonna get that started. If you wanna explain to us the first slide, I can get it there.
I don't have the clicker, so well, in any event, the first slide is the first slide, and top 10 tips for young lawyers that lead to success in court and out of court. And the first part of the slide is a quiz. Which one of the panelists most resembles the person at the bottom of the screen?
You also have, when you walked in, were given a handout that has a copy of the slides on it, so you can look at that while I try and figure it out.
All right, so second slide, Judge.
Oh, the second slide, as you can look at your hard copy, is the top 10 tips for in court and out of court. The first is be civil, ethical, professional, and prompt. Number 2 is know your case and your judge. Number 3, know the rules and follow them. Number 4, choose your battles. And number 5, ask for help if you need it. And then out of court, number 6 is build relationships, get involved. For number 7, number 8, identify what you want. And number 9, take charge of your career. And number 10, be true to yourself. Okay, moving on to the third slide.
Actually, while you're doing that, maybe
Yeah, go ahead.
Laura and I can chime in on a few things. Judge Holderman and I began practicing law at the same time, and it was an era where things were extremely formal in court. For instance, men weren't allowed to wear sport coats. You had to wear a suit. Anything but white shirts was frowned upon, and of course ties, anything like this would not have been allowed. Maybe not so much in front of a judge, but you never wore it in front of a jury. That's the kind of atmosphere I think that we expect as judges. The reason I'm saying that is because when you're a young lawyer and you're feeling your way around in court, the habits that you form now are going to stay with you for the rest of your law practice. When I was at Chenner and Block, tried cases in 17 states outside of Illinois. And the reason I'm bringing that to your attention is because every judge and every clerk in every judge's courtroom was different. But my approach was always the same. I was overly formal. I was overly polite. I was always extremely careful to make the clerk, either the judge's law clerk or more commonly the court clerk, like me, even if they were mean, even if they thought I had no business being there because I was from Chicago and they were in Jackson, Tennessee. The decorum, bringing decorum in your practice, I think, is extremely important. I think it's extremely important way for you to convince a judge that you're a serious lawyer. The things that the three of us most complain about, you people don't do, or you wouldn't be here. Chewing gum, being late for court, missing court altogether, coming in looking like you just got up from a wrestling match, being disrespectful, fighting with the other lawyer in front of the judge, interrupting the judge, are things you don't do and you wouldn't consider doing. The only exception to that is sometimes you feel like you're being taken advantage by somebody, either by the other side or by the judge, and you feel that you have to blurt something out in order to get control of the situation. That's usually a wrong thing to do. Most judges understand exactly what's going on in front of them, and you don't need to take control of the stage. So that's my opening statement.
Okay.
Do you have anything to add, Judge Liu?
I just have a couple of things briefly. And I only want to add this because I'm the only female judge on the panel, so I can risk this sort of tip that I'd like to give. Women who are practicing, especially young women, we sort of are always trying to define ourselves. You know, when I first started practice, that was when Ally McBeal was on the air and LA Law. and I remember thinking, where are their blouses? You know, they just had a jacket. You know, when Judge Mulroy and Judge Holderman talk about decorum, walking into the courtroom when you step up, that's the very first impression. And if you're going to be on a long commercial case or some other long case that will require your repeated appearance, that first impression is very important. How you dress, how you carry yourself, how you approach. One of the things also is, in terms of decorum, be polite. I always thought that when counsel approached the bench, you could always tell if there was a hostile environment between the two of them. If there is some reason that you should have talked before coming to court, make sure you have a good answer for why you haven't, if you haven't, or try to make that effort. And that's basically it in terms of coming up to the bench. That's really all I have to add.
It's absolutely imperative that you, if you're going to have long-term success, that you conduct yourself in a professional way at all times. And professionalism is conducting yourself in a way that garners confidence and respect for you and your ability to advise others and to advocate on behalf of others. So you should always have that in the back of your mind. Is what I'm doing now garnering respect and confidence in my ability? And so if you keep that in the back of your mind, that will assist you in every setting, every professional setting that you're in. And although we could argue about what proper courtroom attire is, it is not quite as formal as it was when Judge Mulroy and I started out back in the dark ages, certainly in the last century. But
That's right.
it is still a formal proceeding. And in fact, the formality of courtroom proceedings really is part of the process to garner respect and confidence in the decisions that judges make and in your presentations.
And really, that was slide number 1 that you have in your materials. Slide number 2 talks about whether knowing your case and knowing your judge. I think that we're all in agreement that the most irritating thing that lawyers do, and we have a list of a lot of those, is when they say, I don't know anything about the case, I'm just here on behalf of another lawyer who couldn't make it. Well, you know, here I am. I have 650 cases. I have 40 cases scheduled for the morning. Now, what am I supposed to do with that information? The plaintiff knows the case. The defendant doesn't know the case. Well, I go on just like I would if the person was there who knew something. I make rulings. I make decisions. I set time schedules. And if you sent somebody over who didn't know the file, then your client is going to maybe complain about that. Don't ever put yourself in that position. Even when you've been being asked to do a favor, they'll say, look, it's just a routine motion call. It's just a routine status call. Just go over there and ask for 21 days. You have to do more. You have to verify. Trust but verify. You have to look at the file. You have to be prepared just in case the lawyer who's telling you just to go over there and step up is wrong. You need to do, on a second point, research on your judge in the same way you do research on your case. Even though you know the case isn't going to go to trial, even though you know it's going to settle, you need to, especially with Google and especially with other lawyers who are going to court all the time, understand what you're facing when you go into court in front of your judge. Do some research. I am one of those judges who will decide a motion without briefing from time to time. So if you file a motion to dismiss affirmative defenses, I'll read the complaint, I'll read the affirmative defenses, and I'll rule right then. So you've got to be prepared when you walk in on a motion that I might actually decide it then and there. That strikes fear into some lawyers' hearts. It brings joy to other lawyers who are sick and tired of briefing motions that don't need to be briefed.
I'm going to add also to that what Judge Mulroy discussed. When you walk in, sometimes one of the things I want to know is the procedural history. I want to know if a party has asked for an extension before, how long it's been since that deadline has passed, where we are on discovery, perhaps what other motions have been ruled on. And that goes to the issue of coming in unprepared. You need to know substantive issues about the case, but you also should have a procedural familiarity as well. With federal court, you should be able to just pull the docket, and it runs it down for you what the last couple of orders are. And when I used to go into court, I had with my pleadings file, the top page was the PACER report. The last page, I had a tab for the judge's standing orders. But you should know what's been happening in the case, even if you're just stepping up.
Judge, could I ask you
Sure.
to talk a little bit about PACER? You mentioned PACER.
Oh,
I just want to
okay.
make sure everybody knows what that is.
The question was if Judge Liu can explain what PACER is. I think we may have been able to hear you, but just in case, I'm repeating it on the microphone.
PACER is the superior electronic filing system that Judge Holderman ushered in when he was chief judge. We have something in state court, but PACER is really excellent. What you do is it is an electronic filing system that some of you may be familiar with. You would file it online. It's mandatory filing, but it also will print out a report. If you go to PACER, if your firm has a subscription or you have a subscription to it, it's really helpful to pull it out, and it will give you numbers. Okay, there's a number for every entry, motions that are filed, the notice of motions, the judge's orders, and I believe still on the report, the order and the text of the order comes right out on the summary. That way you have it in front of you, and every time you go back into court, just update it. That way you have a report and you know what has happened without having to go through the entire file if you are just walking up for somebody. But knowing the procedural history is important. I will check, and like Judge Mulroy, I'll rule on the motion too if I've read it and I am ready to go without a briefing schedule.
And I'll let you in on a little secret. The PACER, the Public Access Computer Electronic Records, is available not only online, but the little secret is we've now gone wireless on my floor at the courthouse and the 18th floor. I'm on 21, and so you can walk in with your computer and you can pull up PACER on your computer at counsel table before you step up to make sure that you have the latest word on the schedule that is taking place. And if a partner or another lawyer says, just go over and see Judge Holderman and ask for 21 days, and that's the first thing you should do. The next thing you should do is to evaluate what are the issues that the judge is going to be asking about. And that's why kind of the key to showing up in front of any judge at any time is for you to anticipate what the judge is going to want. And all you have to do is put yourself in the judge's position in your mind. If I were the judge, what would I want to know about this case? And so many lawyers do not do that. You can tell when I ask them a simple question about any easy point on the case, they haven't thought, oh, well, this is the logical question that the judge would ask. And so that's, I guess, my key tip in showing up in front of any judge at any time.
Well, you know, this is a great point, because this is something obviously that's near and dear to our hearts. And not all judges are like the three of us, but the three of us spend hours reading papers before a court call. Your job as a litigator is to go to court. So we expect some expertise from you. When you stand up and you express ignorance on either the status of the case or the background of the case or the substantive motion, and I've just put in an hour reading about it, and now I'm the only one of the three of us who knows what the case is about, that's irritating. It doesn't mean that you're going to lose. It doesn't mean we're going to take it out on your client. But it certainly causes me to lose confidence in your ability as a lawyer, which is not a good thing for you, since I'm going to be seeing you every 30 days until this case is over. You want each appearance to be something memorable in a good way.
Okay, I figured out how to use the PowerPoint, so I'm going to go to the next slide, slide number 3.
All right.
Here. Yeah, they don't teach you PowerPoint in law school. Okay. Know the rules. And before the judges get into this, actually, Judge Liu was kind enough to print out some of the rules you need to know to go into her courtroom. And Heather over there with the mic and George next to him, there's some copies of those you can pick up when you're leaving, but she can tell us a little more about what she printed out for us.
Thank you. You should, I'll talk about state court. For instance, there are local rules to state court, from things to filing, to notice of motions, to spindling a motion, to presenting. That's just the first level. After your rules of civil procedure, your rules of evidence, you need to know what the rules are to come to court, to present your request for relief. Then you should also make sure the particular section, if there are rules that apply to that. In Chancery, it starts at the top. There are general administrative orders on how pleadings look, on how emergency motions are conducted, how do you ask for certain types of relief in front of the judge. And then under each particular section, for instance, the mortgage foreclosure section has its own standing orders for the floor that everybody follows. That tells you everything from what you are required to do if there is, for instance, a deceased party in the case. And then each judge also has a series of standing orders. If you are going to have a mortgage foreclosure case, I will just expect that you know all of these rules, even if you don't always practice this particular area. And it's difficult because some of the firms that don't handle this on a volume basis will come in and they're not prepared. But I have to expect and treat everybody the same way. So again, just make sure you've done that research. Put those rules or orders at the tab underneath the pleadings so anybody that handles your file has a chance to look at that.
Great idea.
Judge Holderman, do you have anything to add from the federal perspective?
Yes, every one of the 94 federal district courts in the United States has a website. And that website has somewhat of a uniform tag, so you can always find it. It's the first two letters of that state in which that court is located. And if it's the northern district, it'd be ND. If it's the southern district, it's SD. And so you can find out, go to the website of every district court in the country. And every district court in the country is required to have its local rules available to you online. Ours are available in the Northern District of Illinois. And in addition to that, each of the judges on their individual pages has a standard procedure that they follow. So before you leave your office, or even when you're sitting and trying to decide what district do you want to file your lawsuit in, if you have various districts available, you can check out the websites of those district courts and the potential judges that you may get in connection with your case. And so each judge has that available to you at all times. And of course, you should, when you go into federal court, you should know the federal rules of civil procedure. If it's a civil case, if it's a criminal case, you need to know the federal rules of criminal procedure. And likewise, if you're going to trial or an evidentiary hearing of some sort, you need to understand the federal rules of evidence. So those are the rules I'm going to be applying, and every other district judge is going to be applying in your case. So you should know the rules, and you should also know, if you've got a motion in front of the judge, know that the standard of review in connection with that motion, or the standard that has to apply to that motion on a motion for summary judgment, on a motion to dismiss. A lot of times lawyers in federal court come in on a motion to dismiss when they really mean to file a motion for summary judgment, because they've got this document that's separate from the complaint, but they've got this document that shows they should win. And a lot of times they'll file a motion to dismiss when I have to convert that to a motion for summary judgment and then go through the procedures of the local rule requirements of Rule 56. And so you should, you can apprise yourself just in the quiet of your own office at your computer of all these rules and be knowledgeable about them before you walk into court.
Next, we have choose your battles.
I said a minute ago that when you're starting out in practice, and by that I mean your first 10 years as a lawyer, your habits are forming, and they're habits that are going to stay with you well and into the depth of your practice. the things that we're talking about now, knowing the rules, are not followed by very many people who appear before me. But the ones who do appear before me who follow the rules, I remember, and it's very impressive. All that means is that I pay more attention to you when you tell me something. I have more confidence in you. This sounds, especially the way Judge Liu explained the rules that we have in state court, very complex, and it is. Our state court system is a court system of specialty courts. I'm in the commercial calendar, which means I only hear commercial cases, no personal injury cases, and my specialty lawyers are not as specific as the ones who appear in front of Judge Liu. So if you have a mortgage foreclosure case for your brother-in-law and you have never appeared in a mortgage foreclosure case, you're going to be up against a bank lawyer who goes there every single day, who knows Judge Liu, knows how she does things, knows all the rules, knows what time things start. You're going to be at a terrible disadvantage, especially in state court, if you don't know the rules of the specialty court where you're appearing. Now, choosing your battles is what you're supposed to talk about, but I talked about something else.
That's okay. When we talk about choosing your battles, actually, from speaking with you all, I know you have some different opinions about discovery motions. What do you think about attorneys bringing motions to compel and other different discovery motions?
I like the title of this slide, first of all, which is Choose Your Battles. I don't think you should ever go to court and ask the judge to do something unless you've really prepared the motion and you have a good chance of winning. I see a lot of motions to compel and a lot of motions to dismiss that really are unfounded. There's not enough thought put into them. You don't want to be in a position where you're losing every time you go in front of a judge, even if it's on a motion to compel or a motion to dismiss. You want to go in front of a judge well prepared, like you are on the rules. You want to be well prepared on the motions. I have friends who are experienced trial lawyers. This is a little bit different, but not much, who say that their goal in a trial is to try the whole case without making an objection. They think it looks bad to make objections, to interrupt the flow. They make their points through testimony rather than objections. And it's kind of the same with motions. Be careful before you bring a motion, and don't forget that this is what we do for a living. We hear motions, okay? You don't do that for a living. We do. So we know what the standard for a motion to dismiss is. That might surprise you. We know what the standard for a summary judgment is. That might surprise you too. And we know and we see motions to compel on a daily basis. You have to keep that in mind. This is what you're presenting is not unique. So what you have to do is be thoroughly prepared and confident in your motion before you present it.
And of course, it's important to consult with the other side before you file your motion and make sure that you have been reasonable in your approach to try to work out whatever differences you have, because the judge is going to ask about that. It's going to ask, well, what's the problem with this, and why can't that be sufficient when you're in front of the judge? Because a lot of times on motions to compel, I've found that, frankly, just by asking those questions and having the lawyers in front of me conferring with one another, we can work it out. If not, like Judge Mulroy, I like to rule as promptly as possible on motions to compel and discovery motions. First of all, the standard of review is abuse of discretion, and very rarely are you going to lose on appeal in connection with a motion to compel on discovery. And so you as a young lawyer should make sure that you've documented your conferences, you know what your position should be, and you've given up and compromised on those points that really aren't that important, because it makes the points that you are going to fight over more credible. Just if I can digress for just a moment, we always should tell an Abraham Lincoln story in any Illinois State Bar Association conference. And one of the things that Abraham Lincoln, literally when he was a trial lawyer here in Chicago, and he tried 13 jury trials in federal district court, right here in Chicago before he ran for President of the United States. He was a master at concession.
Yeah.
He would give up things that didn't count. He knew in his mind what counted and what didn't, and that's what made him the more credible trial lawyer in the courtroom. History reports that, and we all should emulate that, in my opinion.
Yes, I was going to add, Judge Holderman was not the trial judge at Abraham
was
Lincoln's
not.
trials. That
No, I was
Although
not
he
the
could have
trial
been.
judge. I could have been. Right.
Judge Liu, do you have anything to add? Okay. Our next slide. Ask for help if you need it.
Can I? I'm gonna talk about ask for help if you need it, but I want to say something to that choose your battle slide. It is, you can be intimidated when you're starting out as a lawyer. You can be intimidated by older lawyers with big reputations. They can scare you. You won't admit it, but that's how you feel. You can be intimidated by judges too. Your response, selecting your response to intimidation is key to your success in court. You don't always have to be a screamer. You don't always have to say outrageous things. The most effective lawyers are ones like Abraham Lincoln, who keep it low key, sneak up on you, and win the case, and you don't even see them coming. It doesn't help for you to raise your voice and get into arguments about nitpicking things. It doesn't help you. It doesn't give you confidence. It doesn't give you the upper hand. In fact, I think it just goes in the reverse. I think if you can keep your cool and keep your calm in public and with the other lawyer, you're going to get more respect and get your way more often than if you start shouting at the drop of a hat because you feel like you're being pushed around. And I know that's a difficult rule to follow because I've been there. I've been intimidated by other lawyers. I've been intimidated by judges. I've especially been intimidated when I go to another state. Like I was referring to Jackson, Tennessee. I tried a case down there, and it's intimidating. But you can't rise to the bait. If you rise to the bait, then the other side is won. You've got to keep it calm. Asking for help if you need it, of course, is crucial. You can never worry that you're going to sound stupid. You need to find a mentor who will take your questions that you can go to on a regular basis and say, look, I'm going over to court. I have this motion to compel. What do you think I should do? And get his or her opinion. And it's part of building up your network. It's part of, a learning process. You don't have to take the advice, but it's great sometimes if you just talk through a problem, the solution all of a sudden becomes more clear. Right?
Absolutely. One of the other areas, too, is every judge in the federal court has an official court reporter. Every active district judge has a court reporter that's assigned to that judge. My court reporter and my courtroom deputy both know exactly what I'm going to do in almost every situation. My court reporter's been with me for about 15 years now. My courtroom deputy is relatively new. She's been with me for about a year. But I encourage them to tell any lawyer anything that lawyer wants to know about me or my courtroom procedure. Because if the lawyer knows that I'm expecting them to stand up when they make an objection in court, and to speak loud enough, as the president of the ISBA will tell you, my hearing is waning in my later years. And it's better for them, it's better for the lawyers, it's better for me. And so that's why I encourage it. And so it goes back actually to slide number 1 about being civil and polite to everyone in the courtroom. The judge's court personnel is the judge's vehicle of obtaining information about about what's going on in the courtroom before the judge takes the bench. And if you treat them with respect and with courtesy, they will assist you. And you can walk up to them and go, I've got this preliminary injunction hearing. Will the judge hear testimony today, do you think? What do you think? they'll advise you because I've told them, go ahead and advise these lawyers what my procedures are.
I want to add something about comments to the slide. In addition to asking for help when you need it, you have to also, you should consider the advice you might be receiving also when you are a new lawyer starting out.
Absolutely.
And just going back, when I first started practicing, there were very stratified layers. I was a junior associate, so to say. There were senior associates that mentored me, and then they were mentored by partners. And so my interaction was primarily with the senior associate. And I was asked to follow up with some discovery on a complex case. In a particular way, they had asked me to contact a couple of people, and something about it didn't seem right. I think you're all smart. You can do a gut check, and if it doesn't feel right, don't take it at face value. Make sure you talk to the partner or look up the rules of professional conduct, which is where I had to go to find out that what was being requested was probably not consistent with those rules. You have to use your own judgment. Don't follow what somebody's telling you to do just blindly. It's your license. It was your tuition that paid for it. Make sure, and it's going to be you that is in the line of fire if there's anything that you do at the request of your senior associate or your partner or your client that ends up being the issue. So just make sure that when you're asked to do something, in addition to asking for help, you also sort of do a gut check on whether or not what you're being asked to do is appropriate. Just keep that in mind.
That's a great point.
The next few slides take us out of the courtroom. So before we get to those, I wanted to ask the audience if anyone had any questions they'd like to ask our panel. Oh, we have a hand over there.
Now's the time to ask.
Yes.
Great.
Hold on. George is right behind you. He'll be getting you a mic so we can all hear you.
Well, I had a question back with the choosing your battle slide. I know you mentioned motions to compel and motions to dismiss that probably were unfounded. I guess, do you have a rule of thumb of where to draw the line between zealously representing your client and picking your battles, so to speak, when it comes to things like that?
Yeah, that's a great question. Zealously representing your client does not mean filing motion after motion, as you know. Zealously representing your client doesn't mean that you become someone who is a pain, someone that you wouldn't like to have on the other side. Zealously representing your client means you review a motion, you decide whether it should be filed or not, as opposed to, in every case, filing a motion to dismiss, regardless of whether you're going to win or not. Zealously representing your client means asking for help, knowing the rules, understanding the judge, making a good presentation in court, and being prepared. It doesn't mean doing everything possible, regardless of whether you're going to win or not.
And it goes back to that thought process of, if I were the judge, what would I think of this? And that's what you should always evaluate everything that you do in court with. If I was a judge, what would I think of this? And we're all reasonable people. And so if you're honest with yourself about that, you'll be able to draw the line appropriately.
I'm sorry, Laura. Keeping in mind that we hear these motions every day, right? So we know whether there's a good faith, whether there's a legitimate reason for you to have filed this or not. It's obvious to us. It's quickly obvious where some motions have been filed without thought and some motions have been filed with a lot of thought.
I wanted to add also two things. One, going back to when Judge Holderman opened up the discussion with don't chew gum. The other overly evident sort of behavior and conduct is do not speak over one another. If somebody interrupts you, you might stop, pause, and then resume your argument. If you get into a fight or an argument or debate with each other and you start facing each other, it just drives us crazy. It's rude, it's inconsiderate. Don't capitulate and become, basically take on the behavior that you find to be, distasteful just because your opponent is doing it. The other issue is in terms of choosing your battle. I saw Judge Holderman had a really good point about gamesmanship. And this is a little bit related to choosing your battles, but it's more related also to tactic and what you're trying to do. If in the course of being zealous and representing your client, sometimes you get so excited and you've got a great argument and you're going to hold it towards the end. And one of the mistakes that I made early on was holding on to an argument until a reply. And I made that mistake the very last time when the federal judge struck the argument because I didn't present it in my chief brief. Okay, so you run that risk that the judge is going to say, you didn't bring it up in your brief. They haven't had a chance to respond to it. I'm not going to allow supplemental briefing on it. It's out. Just remember that when you're being zealous about representing your client, make sure you don't do something that hurts the client.
Do we have any more questions? Oh, I've seen another hand. Heather can come right to you.
Could you talk a little bit about the importance or strategies for developing a record in a discovery dispute? So where you do eventually want to fight the battle and it's a battle that's worth fighting for a motion to compel, say, what are you all looking for to see that we've gone through with the other party, the back and forth, I guess the correspondence or successful ways of demonstrating to you all that we're not just throwing this in front of you, but we tried to work out the dispute ahead of time?
I think that's another great question. There's a way to build a record in a deposition where you've got a court reporter there and someone, let's say, has refused to answer a question or refused to produce a document. The way you make your record there is obvious. But what we're looking for is not self-serving letters following your discovery conference where, you set forth in a kind of rude way what everybody didn't do or that they were supposed to do. What we're looking for is assurance from both sides that you've had a conversation. Because we're going to be asking you, did you ask whether a redacted tax return would be acceptable? So if we redact, page 5, 6, and 7, is that acceptable? Well, no, you were too busy fighting. We just want assurances that you've thought of these questions and that you've talked about them before you get to us.
Anything else to add, anyone?
Yeah, our local rules, of course, require a conference, and so before you can file your motion to compel, you need to have that conference, and that's the record we're looking for. But if you're thinking about making a record for the Court of Appeals, again, I just advocate, put yourself in the position of a Court of Appeals. What would you want to know if you were on the Court of Appeals about what happened in this case, and then make sure that that's in the record. And a lot of times, if for some reason the judge has not allowed you an opportunity in court to make a record, you should ask very politely, Your Honor, may I make a record on that? And you could even, if you're in front of a jury on a jury trial, and the judge may not want to take the time while the jury's in the box, but you could say, Your Honor, at the close of court after the jury is gone, may I make a record on that? And if you do it politely, the judge has to give you that opportunity, or the judge will get reversed on appeal for not allowing you to make a record.
One real quick point to that also, I've had a discovery dispute. It wasn't a motion to compel, but it was a disagreement over how discovery was presented. It was on a disc, and there were thousands of pages, and they weren't. My first question was, were these bait stamped? And then they had a bunch of depositions that were pending that were coming up, and I'm pretty convinced that the party producing the discovery had organized documents because they were presenting their witnesses. So one of the things you want to avoid is appearing like you were very haphazard or deliberately sloppy with the document production or whatever it is that you're responding. If you're in state court, if your 214 request, your answers to it says, there's a request about particular categories of discovery, and you say, see documents. That's really not a very specific answer. It's one of the answers that produces the judge's response, better.
Okay, was there anybody else I missed? All right, we're going to move on to the next slide. Building relationships.
This is what they tell you about from the beginning of your law school career and maybe your college career, you need to get a network. You need to start working on a network immediately. Everybody that you have a case with should be in your network. Everybody you've had a case against should be in your network. Every time you meet another lawyer, whether he or she is an adversary or a co-lawyer, co-counsel, you need to make a friend, at least an acquaintance out of that person. You need to expand your network for information purposes so that you can go to people and say, do you know anything about Judge Holderman? I've got a such and such in front of him. Number two, most business is sent to you by other lawyers as opposed to by clients, are referrals. And if you don't have a big network, it's going to be harder for you to generate business. And I'm sorry to say that the law is a lot about business, and you have to be able to have the ability to get your own clients at some point in the game.
Go ahead.
In terms of also having relationships with other attorneys, one of the ways you also build those relationships with is opposing counsel. I'll give you two examples. Opposing counsel, sometimes parties that have been taken adversarial positions to you might be asked for references, for recommendations. It comes up in situations including if you're running for judge, something that I had honestly not contemplated, all right? But then I had to go back through almost 20 years of adversarial attorneys, adversarial cases, and ask for their recommendations, and they were very kind and responsive about it because of the relationships and the way that I conducted myself in court. The other thing is, sometimes if you're working with firms that have good networks and they have a lot of clients, there's a lot of conflict work. I also had a situation where the opposing counsel was from a large law firm, and there's a lot of conflicts there because they can't take all of their cases. And he would refer work to me regularly because of the relationship that we had developed during a case.
Every person you meet is a potential client. Every lawyer you meet is someone that at some point in time can refer you business. And frankly, there's nothing more satisfying than having a former adversary call you up on the phone and say, hey, Jim, I've got this conflict that's come up, and we had that case together. I enjoyed the way you worked. I enjoyed your zealous advocacy. And frankly, I'd like to have you work on this case, or I'd like to refer you to this client. That just, it makes your day. When I was an assistant United States attorney, Judge Mulroy and I were both assistants, but I was given the opportunity to go around the country and to talk to other assistant U.S. attorneys in other parts of the country about how to prosecute public corruption cases, because I'd done a few of them in my early years in the office. I didn't realize at the time that what I was doing exactly what Judge Mulroy was talking about. I was developing a network of people that when I went into private practice and a lawyer from Los Angeles needed a lawyer in Chicago, they remembered Jim Holderman, or Buffalo, New York, or Mobile, Alabama. And so you're always developing your network, and you always should be. As President Holderman said in her recent article in the Women's Bar Journal, networking is not a bad word. It's a good word, and it's a way that we should always be working with one another in a civil and professional way.
That brings us right to the next slide, which is getting involved. And before we get into the slide, I just want to say everyone here that the young lawyers are having a holiday party on December 6th at the Cubby Bear, and all our proceeds go to the Children's Assistance Fund, so we'd love to see you there. If you get tickets before November 22nd, they are $35 for a young lawyer, $30 for a law student. We also still accepting sponsorships, so just contact me or someone else from YLD and we'll hook you up with that. Okay. Judge Liu, do you have anything to say about getting involved?
Just briefly, I think I wasn't involved as much during the period of my first 2 years as a young lawyer and then the last 2 years as a lawyer, and I missed out on a lot. I regret those years that I was not more active, because I think it's been the most satisfying thing that I've done was getting involved with organizations that you really care about. You don't have to join every organization and try to make the meetings and just barely participate. Find one or two that you care about and be active in it.
Yeah, it's a great way to expand the number of acquaintances you have. And you should be, you're developing habits again when you start out in practice. And one of the habits you need to start developing right now is how do you generate legal business? Or if that doesn't do anything for you, how do you get to become smarter as a lawyer? And one of the ways to do that is to be involved not only in bar association work where you'll meet people that maybe you'll be able to call up and ask for advice.
I want to stress one of the things that Judge Liu mentioned, and that is do something you're interested in. Don't just get involved with a bar association because a partner says you ought to get involved in this bar. Do something that you care about. And if you care about it, then you'll enjoy it more. It will also bring you greater benefits, both psychologically as well as socially. But getting involved is really important. We are all one profession, and knowing the other people and working toward a common goal in the profession is important. And one other thing that we kind of glossed over in the last slide was paying it forward. You're all young lawyers. Well, most of you are young lawyers, but pay it forward. There are younger people than you that are coming into this profession. Help them. They look to you as role models and mentors, and that's a really satisfying exercise to help other lawyers in teaching too. If you have the opportunity to teach, there is a great satisfaction in watching your students, even not necessarily law students. If you teach undergraduate business law courses or anything in that area, to see a younger person get what you're explaining to them, and to see the light bulb go off over their head, figuratively, it really is gratifying, and it gets you involved, and also allows you to take some of the tension away that comes about as a result of our profession.
Yeah.
Okay. Next slide here is identify what you want in the short term and the long term. Why don't we stick with you, Judge Holderman? What do you think about this slide?
Well, you need to have a 1-year plan, a 5-year plan, and a lifetime plan. I have to say I feel very fortunate that if I had my profession to do all over again, I'd do it exactly the same way. Frankly, having had the opportunities that I've had, I have been able to develop plans, but I did strategize it. I have to say, Judge Liu, when I first started thinking about being a judge, which is when, just a few months after graduating from law school, when I was clerking for a judge, I realized that people, if they're going to be thinking of me as a judge, are going to be talking to not my friends and my colleagues, they're going to be talking to my opponents. And they're going to be going to my opponents and say, well, what do you think about Judge Holderman? Was he ethical? Or what do you think about Jim Holderman? Was he ethical? Was he fair? Was he reasonable? All of those things. And you should always have that in mind if you have judicial aspirations. Frankly, you should have it in mind even if you don't. But that's something that it is good to have a plan. If you don't have a plan, if you don't know where you're going, you're never going to get there. So,
I think it's very difficult to be happy as a lawyer. I think that the stresses are strong. I think the tension is great. I think the lack of self-confidence that you have can eat away at you. I was a trial lawyer, and nobody is less self-confident in their heart than a trial lawyer. You're sure that everything is going to go wrong every day because all you do is prepare for the worst, You put the good over here and don't think about it again. So all you're thinking about is what bad thing can happen. And if you don't have a plan, if you don't have a network, if you can't share this feeling with other people, it makes it worse. A plan is important, and I know sometimes you think it's hard to plan, that events are taking you over, that you're stuck in a place you don't want to be, you're stuck on a case you don't want to work on. Nevertheless, you can make a plan, and you then the trick is having the guts to execute the plan, having the courage. If your plan involves, for instance, going out on your own after 5 years, then you have to have the courage to leave the mothership and to do it. And that's part of the plan. But it's very self-satisfying if you have your own plan. Scary, but self-satisfying.
Again, I want to open up. Does anyone have any questions? We don't have much time left, and I'd like to make sure we get all the questions in if there are any. Don't be shy. No? Okay. Our next slide here is taking charge of your career, which kind of coincides with some of the things you were already saying, but does anyone have anything else to add to that one?
Well, once you identify what you want, go for it. I mean, once you've really decided this is what I want to do, then you should just go for it. And even though you may lack confidence and you may be scared about doing it, if you do want to go out on your own, you want to develop your own practice, you want to go into another area, do it. That's what's going to make you happy. And that's what is important in life as well.
One of the things also, if you are in a firm and you feel like you're getting pigeonholed, you want to try a different area, or you want to get a little bit more experience than you're being given at the particular firm or the practice, you should volunteer. There's a shortage of volunteers, people who can provide, legal services to those who can't afford it, and it's a great opportunity. It might be the only opportunity you have to argue in front of the Seventh Circuit, to argue in front of the Supreme Court, because at the firm, most of the time, the senior associates, the partners, they will want to handle the oral argument. It takes a long time, and this is a way to allow yourself the opportunity and to introduce yourself to opportunities that you wouldn't otherwise have in a firm. So you should, if you want to try out a criminal matter, make sure you have appropriate guidance, of course, but if you can't find an avenue for it, find out if you can volunteer for a clinic, and that way you have a chance to try it out.
And then finally, we have be true to yourself. Does anyone have anything to add on that? I think it's pretty self-explanatory.
It is self-explanatory. There is a phrase down at the bottom of that slide that a mentor of mine, a law professor who then became a federal district judge, who's now passed away, Prentice Marshall, told me early on, well, actually, while we were still in law school, when we were talking about the practice of law, and that is, no client, no case, no client, no fee, no result is worth abandoning your personal integrity. And the temptation to abandon your personal integrity may come in the silence of your own office some evening when you're thinking about a particular matter and you could do something untoward, or it may come in the heat of battle in a courtroom. But just remember that no case, no client, no fee, no result is worth abandoning your personal integrity. If you're always true to yourself and you maintain your personal integrity, then you've always got the foundation to succeed at everything else you do.
That's good advice.
Okay, one last chance. Anyone have any questions? I don't know how often you're going to get... Oh, there we go. We have a brave soul. George is coming right to you with the microphone.
Are there any ethical issues we need to be aware of when we are friending or linking with judges?
I'm sorry, I didn't hear the full question.
Are there any ethical issues you need to worry about when you're sending a friend request, I'm assuming via Facebook, or trying to link in on LinkedIn with a judge?
Not you as a lawyer, but we as judges have some ethical obligations that we have to follow. And that's why a lot of us refrain from participating in that. But I think as a lawyer, I don't know that there's anything, unless you're, I guess unless you're considering, and I know this wasn't part of your question, unless you're considering somehow trying to influence the judge in a case that you have before the judge by doing such a thing. But I don't think you were thinking about that.
Seen by your opposing counsel. If I'm friending a judge, then
I'm sorry, what?
She's wondering how opposing counsel would see it if, say, you were Facebook friends with her opposing counsel. That might look untoward. And I think you were saying it's on the judge's side that he needs.
It's on the judge's side, but I would think, I mean, if I have a lot of friends before Facebook friends, and they appeared before me. Judge Mulroy, when he was in practice, appeared before me. And
Testified before you.
as a matter of fact, you did very credibly. Now that I think about it,
I wish you'd written that.
Was he tuned up?
and we all are friends. But if for some reason you have sought to be a Facebook friend with a judge for the purpose of that case, or because the judge has that case, that's a different situation.
Do we have any other questions? Any hands raised? It's your last chance. I don't think you get to ask questions to 3 sitting judges very often. Going once, twice. All right. I want to thank our panel here. They were excellent.
Thank you.